You've got 1 minute. We are live streaming right now.
Good work. Especially on so far. Yeah.
We are live streaming.
Amber, are you going to do the slide?
Yes. Yeah. Click and I'll click.
Special counsel. Leading over.
Only 4 people on Zoom.
Really?
Wow. Yes.
Did you get the new microphone yet?
Not yet.
Hmm.
It's
It is on its way.
due any day,
Okay.
whatever that means.
Yeah, right.
Does it have to come from Peking or OEM?
Who knows? Who knows?
It's 7 o'clock.
Applicant side.
The wires don't go very. That's loud.
Ooh.
Oh.
It's not working, huh?
Yeah, I can never hear you.
I know.
Mm.
All right, Jerry, we're good.
All good?
All good.
I welcome everyone, both in attendance here and at home, for coming to this special town board meeting of July 19th, 2023. Would you please join me in our pledge of allegiance? I pledge allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Will our clerk please call the roll?
Councilman Chase,
Here,
Councilwoman Corbin,
Here.
Councilwoman Morale,
Here.
Councilman Oliver.
Here.
Supervisor Cusie,
Here. Thank you. I'm going to turn this over to our attorney for such matters, Ben Wisnowski. And the floor is yours.
Thank you, Mr. Supervisor. Okay, so as the board is well aware, tonight we're primarily here to give the public the opportunity. So the reason we're here tonight is to have the town board consider a host community agreement between the town and the developer of the Horseshoe Solar Project in Venergy. And also to allow the public the opportunity to comment on that agreement, which has been publicly posted, and to provide additional information for the town's consideration before they take any action on that agreement. So before we get into the public comment hearing, just for the benefit of the board and also for anybody here tonight, I wanted to go through a little bit about what the agreement is and how we've gotten to where we are. So the deputy supervisor will be clicking through for me. Thank you.
Hopefully. Let me try.
Yeah, that's the one.
All right.
Okay, so I think as everybody knows, this project's been on the horizon for quite some time. The whole solar project is fairly large, about 180 megawatts. But the portion that's been proposed in town is only a small fraction of that at this point. Nonetheless, as everybody is well aware, both this town board and many members of the community have been pretty actively opposed to this project for quite some time for a variety of reasons. Over time, as state siting process has gone on, as I just referenced, the footprint in town has shrunk. The current proposal is for a project that's 8.4 megawatts in size. located in basically two areas, two separate arrays, one north and one south, Gola Road off River Road. And they're separated by a fair amount of distance, so it's not like they're right next to each other. It's worth noting at 8.4 megawatts, this is really basically a community-sized solar project and a half at this point in terms of what's being built within the town of Brush. Obviously, the state has been in charge of doing the permitting for this, not the town. It's ultimately been subject to the State Office for Renewable Energy Siting. The project did receive its permit at the end of last year. And throughout that process, the town had opposed the award. And then once the permit was awarded, the town decided to challenge the permit in court. So in this type of proceeding, you make that challenge directly in the appellate division of the Supreme Court. So the town filed a special lawsuit in the Fourth Department here in Rochester. In that lawsuit, the town was again raising some specific concerns about the project, also opposing the waiver of local laws that the state agency had authorized. Subsequent to that court challenge, the town and Horseshoe Solar began discussions with the goal of trying to address all of the outstanding disputes and issues between them. And the result of those lengthy negotiations are, in front of the board tonight for consideration and in front of the public to comment on. And that is this host community agreement. So next slide, please. I'm going to go over a little bit of what's in this agreement before handing it off to the public. So just first off, stepping back, in general, a host community agreement is a special kind of an agreement between a town and a developer. And what it's doing is it's allowing a town to benefit from a project in ways it otherwise might not. It's allowing a town to have concerns addressed in a way where the state agency might not be addressing them. These agreements can be very narrow and just talk about things like money, but they can also be broad and try to address other concerns a town might have. It's also important to note that a host community agreement, which is specifically between the town and the developer, is very different from a pilot agreement or a payment in lieu of tax agreement. That's an agreement between the developer and industrial development agents. Towns don't have the power to negotiate a pilot agreement. Towns do have the power to negotiate a host community agreement. Next slide, please. So the HCA that we're all looking at tonight can be boiled down to a couple of really key terms. From the town's perspective, what the agreement is requiring is that the town would need to withdraw the appeal it has before the Fourth Department. And they'd be withdrawing it with prejudice, so that appeal is gone. The town's also required to enter into a road use agreement, which is also included as an exhibit to the host community agreement that has been negotiated. I believe in addition to the host community agreement being satisfactory to the town's concerns, I also believe the road use agreement has addressed any issues the town raised in the original draft. And the last big thing that this agreement will require is to cut off future opposition to the project from the town. And there are some limited carve-outs that we'll talk about in a minute. But again, the big three things are town has to withdraw the appeal, it's got to enter a road use agreement, and it can't fight the project to boil it down. On the other side, it's requiring the town to make certain mitigation payments to the town. So there's a financial component here. That's revenue for the town, essentially, that's separate, distinct from pilot. There's also provisions that protect the town's road from construction damage that happens when the project's being developed. And this is also used as an opportunity to address some very specific concerns the town's been raising for a couple of years now. On the next slide, I want to get a little bit into the financial terms because I know they're probably a little bit confusing. First off, the agreement creates revenue for the town in I guess really three distinct ways. The first way is that you'll recall when we were participating in the state permitting proceeding, the town requested funding through the local agency account fund to receive the award. Because there was never an adjudicative hearing in the case, quite a bit of that money was left unspent. So under this agreement, and so under the law, if that money is not spent by the town, ultimately the state refunds it to the developer and the developer can just keep it Under this agreement, the developer will be required to turn over the remaining funds to the town after it's refunded. So that's a $42,729 payment to the town. That should happen at some point in the next year, but really who knows when, whereas will close out the account. They've been slow to do that in multiple cases. There's also a second payment, which is a balloon payment, which will happen at a couple different times. There will be a first tranche of about $100,000 once pile driving construction begins, and a second upon completion of construction. The total amount will be $300,000. That is really kind of tied to the idea that there's potential historic mitigation project the town's considering, but there's still been no firm decision on exactly how all of that money will be used. There is a specific requirement that about $3,000 to $4,000 of that must be specifically earmarked for a historic mitigation project, regardless of what it is. But there's nothing preventing the town from using all of it on a historic mitigation project the town so desires. The last thing in terms of revenue the town will be receiving is 25 years of annual payments. And the first payment starting in year one will be $22,363. That's on top of the $300,000. That'll happen after production of energy actually begins commercial operation. Those payments step up every year, a small percentage. And again, they go on for 25 years. It's worth noting that if there's a pilot, in this case, the pilot will only be for 15. And the way this is structured, you will receive that money no matter what happens with the pilot. So those are the financial terms. There are also, the agreement also creates some obligations for the town. Some things the town will need to do. So obviously, the first we talked about was it's got to withdraw the lawsuit. That's a key component of the agreement. The town also has to agree not to oppose certain proposed changes, the limits of disturbance, local law waivers, and other design changes that have been contemplated during this negotiation. And all of those are described at some level of detail in the agreement and the maps at the end, and the public has had a chance to see them. None of those design changes are intended to increase the size of the project. A few of them are designed to ease construction, allow for things like stockpiling soil more easily, allow for easier construction access. There's one specific waiver of the 200-foot setback, which is required so that Invenergy can move solar panels from the southern edge of a property to the north, which will mitigate a visual impact on a house that was essentially surrounded. That's the kind of changes we're talking about. If by signing this, the town is agreeing to not oppose Invenergy's ultimate request that ORES allow these changes. The town's also agreeing not to frustrate requests for other permits. So, for example, if Invenergy is seeking a building permit or demolition permit or other government permits that are associated with this, the town's waiving the right to oppose those. And then finally, and probably most importantly, the town is going to be agreeing to support Invenergy's request for a separate specific pilot agreement with the Monroe County Industrial Development Agency, COMIDA. The language in there is pretty specific. Invenergy is looking for a $1,750 per megawatt pilot, which should be good for 15 years and will likely escalate. The town under this agreement will be required to support that request. So those are the town's obligations. Next slide, please. There's also a host of concessions that Invenergy has made with this agreement, which I think directly address a lot of the town's concerns. So one major one is that the operations and maintenance building will no longer be in the town of Rush. There's a new proposed building that's being eliminated. Instead, there's an existing pole barn across the street that's going to be retrofitted as a maintenance shed, storage shed. They'll have a parking lot in front of it, fencing around the parking lot. So initially, the town had really wanted to have some level of control over how a new building would look, make sure it's consistent with community character, but that concern is completely mitigated if the building just goes away. It also, I think, eliminates concern about future traffic from an O&M building in town. Another concession we already kind of talked about in the context of setback waiver is Invenergy's agreeing to relocate some of the panels and one of the arrays in order to mitigate visual impact on a house that had been basically surrounded on 3 sides. In order to do that, they've got to move some of the panels into the 200-foot setback. But in this case, that really doesn't matter because the adjacent property is an existing power line owned by a power company. So it's not like it's impacting it, it's adversely impacting a neighbor. Town obviously has been very concerned about impacts on Native American archaeological resources and cultural resources in town. In order to mitigate that concern, Invenergy is going to allow the town to hire its own archaeological monitor. Subject to certain conditions, we'll have completely unfettered access to the site, have another set of eyes on what's going on to make sure that proper procedures are being followed. There's also another concern the town had to do with construction hours. The state permit, which is standard authorized construction every day of the week from 7 in the morning to 8 o'clock in the evening. Invenergy's agreed to some voluntary reduction in hours, so it's voluntary. They can always walk back from this, but they're going to target 8 to 6 Monday to Saturday and 9 to 4 on Sunday. And in the event they can't meet those voluntary restrictions, they've agreed to give the town advance notice so people know what's going on. And we're hoping that's going to be the exception, not the rule. Concerning visual screening, Invenergy's agreed to talk with the town about putting together the form of a final visual mitigation plan before going final and planting. So the town will hopefully have some input on exactly what's being planted and exactly where. Obviously, that's all going to have to be consistent with the terms of the permit. We can't go and ask for more than what the permit allows, but we can ask for specific locations and types within the confines of the public permit. Concerning the road use agreement, which is attached to this, the town had a lot of concerns about the decommissioning bond, which the town could take recourse to in the event roads were damaged and not fixed. So Invenergy's agreed to a $300,000 per mile security, which should be sufficient to completely replace Gola Road in the event that needs to be done. There's lots of other provisions of that road use agreement, which I won't get into. I think the board's well aware of. And then finally, and I think really importantly from the town board's perspective, this agreement allows the town to directly oppose any proposed expansion of the physical footprint of this project. So if there's an amendment 5 years from now, which wants to add another 20 megawatts of panels, the town can oppose that both in the administrative proceeding and potentially even with litigation, and not violate the social community agreement. Whether or not the town wants to do that, that's up to the town, but at least you have the right to do it. So those are the concessions on the developer side here. Next slide. So I did just a couple brief conclusions for you. Overall, my final recommendation to the board is that from a legal perspective, this is an agreement that can be executed by the board and that it does address most of the concerns that have been raised throughout litigation and the proceeding in one form or another. And some of the provisions are weaker than we might like, but I honestly believe it's the best we're going to be able to do within this negotiation. There is one outstanding item, however, there is a provision in the agreement that allows Invenergy to terminate the agreement in the event they don't obtain a pilot in the amount of $1,750 per megawatt. So I have been in discussions with 2 of the taxing jurisdictions, as has Invenergy, and we're not quite at the point where we don't feel completely happy with the response we're getting that the taxing jurisdictions will be happy with those numbers. So I would recommend modifying the resolution tonight if you're considering adoption here to only authorize execution subject to further positive assurance from the taxing jurisdictions that 1750 pilot is going to be something they can live with. That doesn't mean that we have to wait for a pilot agreement in order to execute, but it means we need to hear a little bit more, and hopefully Invenergy can get on that, give us the information and the feedback we need. Okay, and then my last note here, this has been a very acrimonious relationship with the developer for a long time. We've reset it a bit in negotiating these terms. I think in stepping back, that's been resulted in a lot of positive gains for the town. So I would suggest that moving forward, we continue on this track if possible. And that's all I have. Any questions for me?
Thank you, Ben. Did you put a supply of these on the table?
I did not, but I think the agenda is up there.
Okay. Now, I hope everyone saw the public hearing rules and regulations. And I would like to open the public hearing to anyone who would like to speak, either on Zoom or in attendance here.
People that have signed up, is there anyone else that would like to sign up to speak? Well, first person is Phyllis Wicker. Do you want to speak? Oh, I certainly do. I don't understand. We get a rebuttal. We
Thank you.
speak. For everyone, our new microphone's on the way. So Phyllis, make sure you have the right into it.
Good evening. Can you hear it? I can't hear myself. Okay, all right. I'm Phyllis Wickerham, 105 Biondo Court here in Rush, New York. As I read through the document, all I could think of was congratulations to Invenergy. Your calm patience with this board is to be applauded. The company tried for months to have conversations with this board. I know because during 2021, I was a member of this board. I asked several times that the board start working with instead of against in the inevitable approval of this project by ORS. The board wasted taxpayer dollars over and over again. For what? To assert your power? You had no power over the state of New York and its push to implement its Climate Leadership Community Protection Act. If I understand this agreement correctly, the town will receive any host payment less all of the other revenue, taxes that the company is paying. So in the first year, the amount could be well less than the agreed to $2,662 per megawatt. Even if you receive the full amount in the first year, which is $22,363, it's pittance compared to what surrounding communities are receiving because you waited too long to come to this decision table. You should be extremely grateful that they have agreed to refund any unused intervenor funds. Actually, we taxpayers should be extremely grateful that if you choose to maintain a monitoring plan liaison, in my opinion, unnecessary oversight, our tax dollars will not be wasted because of their generosity in allowing you to use these offset funds to offset any reasonable costs incurred by the town related to its rights and obligations under this agreement. The fact that Invenergy allows you to be part of any discussion going forward, should be greatly appreciated. The company over the last 4 years has made significant good faith efforts to make changes to the footprint of the project, but the board refused to acknowledge them. You kept pushing a small-minded agenda. You have wasted time and money, and frankly, it's embarrassing. So to repeat myself, Invenergy is to be applauded for its patience and perseverance. Good luck to them for a speedy construction and production of renewable energy for the state of New York. Thank you.
Thank you.
Who's our next person?
Janet Blocker, are you prepared to speak?
Good evening. My name is Janet Blocker. I live in Rush. I thank you for scheduling this public hearing and making the draft post-community road use agreement available to town residents. I'm speaking and I'm whining as an individual concerned with Horseshoe in my town. I thank you for the substantial efforts of town board members in negotiating this draft. I thank Ben Wisniewski and David Howe for extensive and painstaking attention to the draft, which originated with Invenergy. I congratulate you on achieving many wins for our town. I want to speak about three things. First, a brief history because it carries the appropriate warnings to the current and future town boards if you are to adequately represent residents. Second, a few comments on the host community agreement. And third, questions to the town board about your future plans if you sign this omnibus agreement. A history lesson as I recollect it. In late 2018, the town board announced it was working on a local solar law for the town. That town board was unwelcoming to residents' comments and participation. On Monday, January 28th, I visited Supervisor Frank with this Democrat and Chronicle article about Horseshoe Solar and other solar installations planned for this area. Ms. Frank said that none of this would affect Rush and that she was well informed about solar. In early 2019, I presented the town board with a solar law from Franklin County. It was vastly different and more detailed than the solar law being presented in Rush by Mr. Mancuso. It was my opinion then that he had largely copied NYSERDA's draft solar law. NYSERDA is the state agency ordered by then Governor Cuomo to build solar and wind as quickly as possible. In my opinion, NYSERDA has a conflict of interest when it comes to draft solar, wind, or battery laws. In early 2019, it quickly became apparent that the town board at that time was caught completely off guard when Invenergy announced it was coming across the Genesee River with leases signed by Stokey, Hallett, Moore, Hetrick, and others. In my opinion, the town board was slow to react and continued to ignore residents' opinion. I, for one, had asked Supervisor Frank to hire an attorney who specialized in renewable energy installations. She denied my request. Residents, perceiving a town board unable or unwilling or other conflicts of interest, contributed money to hire Ben Wisniewski to assist in the promulgation of Rush's local solar law. Fortunately, later town boards hired Ben and Gary Abraham as it quickly became apparent that the state's renewable energy mandates stripped town boards of home rule. In a conversation with the Rush Fire Department chief in the summer of 2019, I asked about large-scale battery dangers to first responders. He quickly assured me that Rush would never get any large-scale batteries, that mutual aid agreements and use of the Rochester Airport expertise would protect Rush. We now know from current events in New York City that mutual aid is too slow to prevent deaths and hazardous contamination of surroundings. In the ensuing years, residents have approached the town board about PFAS and BESS. To date, we have no prohibition of PFAS, which we know to be in and on solar panels, wires, and cables. Whether the PFAS compounds are the cancer-causing versions of these forever chemicals has not been proven. Thankfully, we have regulations about BESS, battery energy storage systems. What do I conclude from this history lesson? Three things. Residents can be helpful to a town board that's intellectually curious and willing to listen to multiple points of view. Specialized legal assistance is required when state mandates are as sweeping as these renewable energy goals. Finally, town board positions require lots of time and energy if you are to properly execute your oaths. With respect to the agreement, again, I appreciate the extensive work by Ben and town board members. I realize that RS holds all the cards. Cuomo designed 94C to create this gross imbalance of power. The rest of this is going to sound like whining. Number one, in my opinion, the funds coming to the town in the chart on pages 6 through 8 are inadequate. I value the analysis of the time value of money and the escalator clause built into payments. But Invenergy and other installers are already going to the state and pleading for increased escalator clauses. For instance, Invenergy has an $11 billion contract to construct something called Clean Path. You want me to stop? Do I have any more minutes or?
How much longer?
I'll speak after everyone else has.
Okay. Deal. Anyone on Zoom?
I have no one on Zoom. Town clerk, do you have anyone in the chat? No.
Would anyone else like to speak in this audience? Yes, please state your name, location.
Talk into the microphone.
Tom Morelli, 535 Five Points Road. I just want to say that I am impressed with the progress that the town has made in its negotiations. You know, compromise and negotiations are a good thing to happen between the town and a company, but you know, when the company also has the state on its side dictating what it believes should be the correct political position moving forward, it makes it sometimes difficult on the town to get a fair deal. Yet the town has stuck to it. It has done it without using taxpayer dollars, and it has gotten us a long way from where we were a few years ago. And I'm very pleased that we've made that progress, and just wanted to say that thank you for hanging in there, and thank you for doing a good job and getting us to where we are. Is there further that I would like to see us go? Yes. But compromise is compromise. Thank you all.
Thank you. Would anyone else like to speak? Yes, please state your name, your location.
Hi, I'm Joanne Scanlon, 1633 Rush Henrietta Town Line Road. I also would like to applaud the board for coming to the table in good faith with Invenergy. I know that it has been a long road and a contentious road. I feel as though, you know, if we had entered into the host community benefit negotiations earlier in the process, we would not have had to go to an appeal process, which did in fact, you know, cost the taxpayers some money. But I do feel as though this is a great agreement. I like the fact that you have some money now that you will have at your discretion to do some good things for the town. And so I do want to thank you for your hard work. Like I said, I know it's been very difficult. And I think that this is going a great way towards making us energy independent and to improving the lives for our children and future generations. So thank you.
Thank you very much. Would anyone else like to speak? Yes.
That's my mouth. Can you hear me? Hi, Mary Ann Rizzo, 25 Stowe Road. So I want to apologize first because I couldn't understand everything as I tried to decipher things, and I still have a lot of questions. So I would want to encourage the board. I know you work hard to maybe have a Q&A for the residents, because it's a community benefit agreement, and I'm not sure. You know, I want the community to benefit, and I want to make sure the community agrees. I know that the attorneys, and I think he's probably doing a great job. He said that this agreement has addressed all of the outstanding disputes, and I really don't think it has. And I actually want to encourage you not to sign it tonight. One question I have is that, you know, how would the pilot add up versus if they were taxed? Does this mean that our town is now accepting the pilot? Because I think that we opted out of the pilot. So how much would the town get with the regular tax rate? How much would they get with the pilot? That's a question I have. I want to understand how Comida interacts with this whole thing. sounds like they have to get a pilot to get the Comida. The decommissioning, this is in, number 6. When does the decommissioning begin? Does it begin, is there a date for that? Or I hope I'm here in 25 years, living on Stall Road. And I want to know, is there a specific date of decommissioning? And I know that sometimes solar panels can still give out some energy, another 5 years, maybe to not the greatest extent. So what is that decommissioning date? Would it be 2049? Or, if it was to be implemented in 2024, would it be 2049? So that I think, maybe it's in the other agreement that's written. 7.9 miscellaneous provisions. The company, it says here, the company agrees with the town prior to finalizing screening that they would, quote, consider the town's request for modified visual screening. To me, this is not a good document if it says that they're going to consider the town's request. It's very weak. And I don't think we should sign it based on that. That alone is one important point. Consider the town's request. There's nothing there that says the town is protected. Screening is important. And I think we need a finalized plan for screening before moving forward. Demolishing the building. So 7.11, demolishing the buildings adjacent to the substation. So with the buildings, one of them, is that a home that's there right next to the substation? As I thought it was really a residence. So it just goes to show you that this is a residential area and we're going to even take down a home for this, which to me is very sad. But then maybe the homeowner decided to sell. I don't know, but it's still sad. Because essentially what we're doing is we're industrializing Gold Road. And I'm upset about that. Because I'm working on the comprehensive plan. It's zoned residential. It's not zoned limited industrial and it's not zoned industrial. And I don't think anyone who's working on the plan or at the community would ever have decided that. And suddenly, and I know I think I'm preaching to the choir here, but it's still signing this historic preservation 712. The company agrees to, again, quote, consult with the town before finalizing any historic preservation mitigation. That's a very weak part of the contract for the town. So they're going to consult with the town. Well, that doesn't mean that the town is going to get what they want. So to me, that's just very weak. Okay, so I think you really should write it in that the finalized plan for historic preservation will be written in the document and clearly delineated. So I'm really glad that for the Chris, that there was some.
You're at 5 minutes. How much longer are you going to need?
Well, I was under the impression, Jerry, that for public hearings that you used to give as much time as, but I'll come back if you'd like me to, but
If you can come back, that would be fine. Thank you.
I hope I wasn't boring. I hope I was not boring.
Never. Would anyone else like to comment? Yes, please state your name and location.
And we have one on Zoom after
Oh, good.
the president.
Good evening. My name is John Cameron. My wife Debbie and I live in the town of Rush. We actually live right at Ground Zero, right across from Gold Road. We would like to thank the board. I know it's been a lot of hard work, and I think that we made a lot of headway when you look back the winding road we traveled. I think it was difficult given that the energy via the state held all the cards here. So I think all in all, mainly it's a remarkable job. The one thing that I'm concerned about in the agreement is noise and construction hours, given where my proximity to the project. And it says on page 16, the siting permit allows construction hours from 7 a.m. to 8 p.m. Monday through Saturday and 8 a.m. to 8 p.m. on Sunday. The company agrees to endeavor, although it's not required, to limit pile driving in the town to the hours between 8 a.m. and 6 p.m. Monday through Saturday, and the hours between 9 and 4 p.m. on Sunday. There are a number of problems with that. Number one, outside of pile driving, it appears that Invenergy will still be able to do other construction between 7 a.m. to 8 p.m. Monday through Saturday and 8 a.m. to 8 p.m. on Sunday. And even pile driving, they're not guaranteeing that they're gonna live up to these more limited hours of 8 a.m. to 6 p.m. Monday through Saturday, and 9 a.m. to 4 p.m. on Sunday. What I would ask for would be for all construction, pile driving, anything, 9 to 5 seems like reasonable hours Monday through Saturday. And I think Sunday there shouldn't be any construction on the site. So I'd ask the board to give that due consideration. Thank you.
Thank you. Would anyone else here like to speak?
Supervisor, we do have one on Zoom.
We will, let's have,
I told Arthur he would be next on Zoom.
oh, yes, by all means,
Arthur, if you would unmute yourself and turn your video on for us.
in 5 minutes, Arthur.
I'm gonna need much less than that. Arthur Avila.
Go ahead, Arthur, your
1000
time begins now.
Okay, 1000 Rush Scottsville Road, Arthur
Oh, I
Avila.
cannot hear you, Arthur.
You cannot hear me. Okay.
Does not look like you're muted.
Amber, I can hear him fine on Zoom.
Okay, can you hear me now without the headphones?
Arthur, do you hear me?
I can hear you. Can you hear me?
Very little.
I can hear Arthur.
Dan Chase, can you say something? Can we hear you?
Can you hear me, Amber?
No. Sorry.
No.
Oddly.
Yeah.
That happened at Conservation Board.
Someone must have their stuff again. Okay, is that? All right, Dan, say something. Let's see if we hear you.
Can you hear me now, Amber?
No, I want
No.
to test it. Test speaker.
No.
I'm not as- All right, Dan, try something now.
Now, can you hear me? Anything now?
Faint.
And test.
Still nothing?
Yeah, I can hear you, Dan, but they can't hear us.
Yes, yeah. So it's not our headsets. It's got to be something on the town hall end.
Yeah, exactly.
What about speakers, rules, that audio?
Yeah, for some reason, they're not getting audio from those of us on Zoom.
Yeah,
But I can hear you on Zoom and I can hear them in the room.
yep.
Trying to think of what that might be.
Yeah, I don't know what the problem is. I posted on the chat for both the Amber and Pam that I can hear them and you guys can hear me, but
Everyone at home.
as-
Uh,
so you guys on the town hall can hear us at all yet?
yeah. Hmm. Anyone else have an idea?
Can you hear me now?
Like that, try playing it on echo, this one here.
Anything yet, Amber?
I just sent a text, I mean, a chat saying that maybe they should try to use a speakerphone for the audio.
No, speakers in the ceiling, they come through here. Did you guys have the same thing at the conservation board?
Yes.
Yeah. I don't have much to say, so I can write down in the chat if they're okay with receiving it like that. So they can
Try that, Arthur. If you want to just type in what you have, just tell them that this is what the statement you wanted to make. And see if maybe Amber could read it.
Okay.
And that,
Can someone reach out to them so they can get the meeting going so that?
Yeah, I'll send something out I'll text Amber right now.
Okay, thank you.
it's not getting from there to there. Right, if someone changed something and we're trying to figure out what to do, last time, all we did was do it. So. Well,
It's embarrassing.
I know, it's really annoying, right? Okay.
Arthur, all speakers have been tested. Arthur, I'm gonna give you my phone number and you can call my cell phone, and then I'll put my cell phone on speaker up to the microphone. Is that okay? Arthur, can you hear me? Can I hear me?
Say yes or no.
I can hear you.
Shake your head.
Arthur, I'll send it to you in a chat.
You can read my comment on the chat.
Dialing hopefully now.
There's somebody in the waiting room too.
No, everyone's in. I just let Hans in. Here he comes. Hi, Arthur.
Hi.
All right. We have you on microphone. Go ahead, Arthur.
All right. The comment that I had is regarding the payment schedule that is in the contract. I noticed that years from 1 to year 25, it grows at a compound rate of 1% a year. And that is way lower than the current inflation rate. And it's half of the target inflation rate from the Federal Reserve. So if there is any room for the town to get it at least up to 2%, it would be wonderful. But I don't know, given the past history that we had with the horseshoe, if there is any wiggle room for that. But I want the town to be aware that that payment and what is in the real amount of dollars today, it's going to decrease over time.
Thank you, Arthur.
All right, thank you.
Thank you. Was there someone else on Zoom?
No,
No.
no. We had two people in here that still wanted to continue to speak.
Yes, I
Oh,
remember.
I'm sorry, Ethan was next.
I changed position.
He was hiding behind the microphone.
Good evening, Ethan Christ, 8309 East River Road, right in the heart of the installation. Just a couple comments. One's not for the public record, but there's a car outside with a set of keys on top. You have a car that's black and might be a Honda. You might want to check that out. So on the official piece, yes, it's been a long and winding road for sure. Thank you for all your efforts. Just a couple comments. The main one is around the Sunday construction for sure. I echo the earlier comments. Because we personally are surrounded by so much of that and will be impacted heavily by the construction. that has a significant personal impact on us, particularly as believers. We believe very strongly in celebrating the Sabbath. So that construction will violate everything we personally believe. And it will be a tremendous disruption just in terms of your life, your living standards there. To have 7 days of construction for months on end is not what we signed up for when we moved to Rush. So that would be my main comment. Obviously, there's plenty of other concerns around the agreement, but I would echo the thanks for your sticking with it. And I would say that the money the town spent to counter some of these actions was not badly spent. If we don't stand up against the state or other things that are trying to force things down our throat, who is? So I'm fully in support of the monies that were spent. That's all. Thank you.
Thank you, Ethan. Yes.
Carol Stevenson, 7740 East River Road, right opposite Gola. Thank you so very much for all your work. All your work. And what a it's just amazing. So thank you. I grew up in Brooklyn on 85th Street, and when the Verrazano Bridge was being built, eminent domain happened and they took out so many houses, and my house was 5 houses from the thruway when the bridge came from Staten Island to Brooklyn. And 800 homes left, 7,000 people had to move, but Brooklyn in those days, this was in 59 to 69, had 2.5 million people, and here in Rush we have 3,000. So when you sign up in Rush, you don't think construction will happen like industrial size. So when I go to bed, I hear the 800 chickens from the Watsons, and I hear some birds and I hear some coyotes, but I will echo with what my neighbors are saying about the noise. And I wondered how long it will go. It took 10 years to do the Verrazano Bridge, so I just wonder how long this construction would be. That would be helpful to know. But mostly, thank you so much for what you did. Thank you.
Thank you, Carol. Would anyone else in this audience like to speak? Would anyone else on Zoom like to speak?
Not on my screen, Town Clerk, any on your screen?
Then I will call Janet Glocker back up to the podium so she can finish.
It's interesting that when I left off, I was questioning the adequacy of the payments coming into town. And I certainly agree with Arthur. Invenergy and other installers are going to the state and pleading for increased escalator clauses. Invenergy has an $11 billion contract to construct something called Clean Path. This Horseshoe Solar is part of Clean Path. The agreement between Invenergy and the state was signed within the last year or year and a half, but already Invenergy says supply chain issues and the increased cost of capital are such that the state has to pay more. Our host community agreements recognize the value of $300,000 up front, and I'm pleased that it does. But what about 10 years? What about 15 years from now? Why can Invenergy tell the state it has to receive more, but we are entering a long-term contract? I doubt if we go to Invenergy and argue for more money that we will be successful, but I would hope that that would be the case. I appreciate that the town can hire an archaeological monitor to protect indigenous artifacts. SHPO has abdicated its responsibility and is silent. New York Executive Law 171, Discovery and Disposition of Human Remains and Funerary Objects, takes effect on August 1st. I know that we believe that because it's a state law, both Invenergy and the town's monitor will have to follow that law. But I also believe that the New York State Constitution protected home rule and agriculture. Please, town board, if you sign this agreement, reference the new legislation. I can provide a copy of this legislation if you wish to append it to the agreement. I have some questions. I know from other wind and solar installations that multiple issues occur with changes in plans, interpretation between the installer and the town. Will you hire a specialized attorney to monitor these changes and protect the town's interest? I mean, no disrespect to you, David, but surely we've learned hard lessons about the intricacies of renewable energy installations. As a resident, I ask that you do so. Hudson Energy has applied to the grid operators for a potential new industrially sized solar installation to be located in Rush. It will be called Hudson Energy Rush Solar and BESS. Please immediately begin fact finding. It will use the Mortimer Gola site for its connection to the grid. How will you protect our first responders if RS forces a lithium-ion large-scale battery upon us? Remember that Governor Hochul has increased New York State's battery goal to 6,000 megawatts. She has doubled Cuomo's goal. I know that the town will not be inspecting installation plans or the installation itself as it occurs. That's part of the RS permit grant. I don't like it, but it is what it is. The Department of Public Service will be responsible for these inspections. There are always unintended consequences with these relatively new ventures, new discoveries, new benefits, as well as safety concerns. I attended a meeting of the Livingston County Planning Board and the issue of something called step and touch potentials and equipotential zones arose. Safety issues for workers and telephone interruptions for residents dependent on telemedicine monitoring of heart and lung functions. Please assure me that you will question the Department of Public Services representative about this phenomenon, as well as PFAS in the water table, streams, and surrounding fields. After all this whining, I want to close by again thanking the town board, Ben and David for your work. I know you've represented the town's interests well. Negotiations are difficult, and I fully support and am grateful for what you've gained for our town. Thank you. This statement is not notarized, but I will make it available to you tomorrow to assist in drafting minutes of tonight's proceedings.
Thank you.
Hi, Mary Ann. I was talking about the Chris property, and I want to say that I feel better that you've reduced the panel size by 4 acres. I was always thinking about what it might be like to be them, and I didn't think that was going to be that great for them. But the company acknowledges that this modification quote requires a waiver of a 200-foot property line setback to the north and to the west. Now I'm to the west, so I know now that these panels are going to be, so maybe when, you rob Peter to pay Paul. And so not only me, but the Meadowwood residents, that's 200 feet closer to me. And it wouldn't be so bad, but the panels, it's not just what's in the mitigation or the remediation, but it's what's left out. And what's left out are the 17-foot panels. There's no mention of it whatsoever. So to have these 200 feet closer to me and Meadowwood residents and the 17-foot panels, wasn't at all addressed. So I feel this community agreement is insufficient. And the 3 biggest issues are, of course, the setbacks, 200 feet, the screening. And again, it says we'll consider what the town board consider. And then the panel height, once again. If you've ever seen or know about the statue David, it's in Florence, Italy. It's a beautiful sculpture by Michelangelo. It's 17 foot high. And that's as big as a 2-story building. In fact, my barn, which I've mentioned before, I actually measured it today, and it goes up to my barn window and then 3 feet higher than my barn window. Come see my barn, see how high it is. I think you really need to think about the 17 feet. And I know that, we've been in negotiations, so. And I'm the person that loves, loves solar panels. I have solar panels on my house, as you probably know. I was a member of the Energy Advisory Committee. I have encouraged the town to move toward renewable energy. I understand climate change, and I know we're in a climate crisis. But I've also been to all the town board meetings for home rule regarding the solar sightings, and I'm a strong component of green energy. But even though saying that, I know, and I've said this before, I know that there are other solar companies that would come into this town. They've already told my neighbors who've got about 20 acres, they would like to have panels on their land. So even though solar horseshoe goes away, which I don't think it's going away, and I know you've done your best, other companies will come into town and they're going to offer the same thing, and they're going to follow town home rule. So it's just so that's why I'm against it, because we could do this right, and this isn't right. So I want to go on record. I also, and I know that this doesn't have to do with Rush per se, but I know that I think the one oak tree on East River Road is being spared. Is that true? And that's good. Between the Chris home and headed north, and that's a Savannah oak tree, a very prominent, prestigious tree. And I know even in Caledonia there are over 200 of these Savannah oak trees. And I hope that Invenergy is saving every last bit of them, because if we're really about renewable energy and the environment, it would be just such a shame, a criminal to cut down these Savannah oak trees to make way for solar panels. So please don't sign the agreement. I know you're doing your best, but perhaps have a question and answer for the community, because there's still a lot we don't know. Thank you so much. And thank you for spending that money on behalf of the town to do whatever you can, because this is a really big project, and it's going to affect all of our lives for years to come. Thank you.
Thank you. Once again, would anyone in this room like to speak? I gave you your chance, then I'll speak. I have a communication from David and Mary Slayton, who live on West Rush Road. We are not able to attend tonight's meeting, but wish to comment on the hearing regarding the Horseshoe Solar Project. Not sure that this will be included, but we are hoping that the board will oversee road issues that include equipment, heavy trucks, etc., that will be necessary to the project using our roads. That will cause damage, noise, and hazards to the town residents. We certainly would not want that equipment traveling down West Rush Road, and we are hoping that you will support that. Thank you, David and Mary Slayton. I will give you one more chance. Yes, sir. I'm sorry, yes, ma'am.
Oh, well, I'm sorry, I forgot one thing. So at one point, Margarita Wells, who was initially the I don't know, supervisor or PR person, she was talking to the townspeople about a host community benefit, and she heard we were building a park at the 100 acres park, nature park, and she said that, oh, well, we'll be able to, as a host community benefit, we'll be able to help you out with building that park. And I just wonder, is there still a possibility for any help with that from Invenergy? It's a question I have. Thank you.
Thank you. Anyone at home?
No.
I don't see anyone else who wishes to express their opinion, so I will declare the public hearing closed. Ben, would you like to comment on any?
Maybe one or two things. There were a couple provisions, sorry.
Yeah, that's all of your,
you know. I think there are one or two provisions of the agreement that I think weren't represented quite accurately. So first one regarding the yearly payments. I think the board is clear that that is the minimum the town will receive, period. They can never receive less. It doesn't matter what the pilot does, it doesn't matter what full taxation might be. No matter what, the town gets the minimum payment. So how that works is every year the town is due a certain amount, if Energy knows it. The town will receive some portion of that from a pilot or taxes, whatever's in place. There will be some small amount paid towards special district taxes. And then the remainder will be paid as a host community payment to make the full amount to the town. So the way this is structured, the town is actually insulated from the frequent changes in state tax law and the relatively short 15-year term of a pilot here. You know what you're going to get for the next 15 years. So that was the first thing I wanted to talk about. There is actually certainty on this issue. You know exactly how much you're going to get every year. There was a related question about, the town failing to really compare what this agreement would do versus the pilot and the tax. And I think what I just explained is that we have done that, in fact, and this gives more money than the town would receive from pilot or taxation by quite a significant amount. So that's good. With regard to decommissioning, the agreement does discuss decommissioning, and I don't have a copy of it in front of me, but there are clear parameters that allow the town to invoke the decommissioning clause. So basically, if the project stopped operating for a certain amount of time, typically under a decommissioning plan, then the town will require it to be decommissioned eventually, and if the developer or the owner, whoever it is at that point, fails to decommission it, then the town could take recourse to a decommissioning bond, and the town would have to oversee it, using the bond money. So you're unlikely to ever be in a situation where it's there forever and no one's taking it down. There will always at least be the decommissioning bond available to the town in the event, it's owned by a bankrupt entity, they can't afford to decommission it. Concerning requests for screening, I understand that the language is a bit squishy in the agreement, but what the board should understand is that the permit doesn't require the applicant to talk to you at all about the screening. So it actually is a concession that they're even going to talk to you. And, given the relationship with the developer, hopefully Energy will listen to the request in good faith. The town understands they can't ask for too much. But there has to be some latitude in what's being put in. Concerning the setbacks, Amber, can you pull up my PowerPoint? So I understand the concern that by moving panels into the setback to help one landowner, I understand the concern that you may be harming another. But if you can go to I think it's the last map on here. Another one, yeah, that one. So the original panel area went all the way down to here. So this house really had panels on all three sides, and the vendor's proposal was to take the panels that were down here and shift them into this green area. And you can see that it goes all the way up and then along the top. The oak tree we were talking about before is over there, by the way. So that the question is, all right, we're helping this owner. What about who was benefiting from this setback? Well, this whole parcel here is an existing power line. So there's no resident there that's benefiting from the setback. And I think that those were the biggest things I wanted to address, to clarify for the board. Did you have any questions for me about any concerns that were raised? I know a lot of the ideas that came up, we have actually, considered, so.
And can you just address the noise that the permit because there were a few comments about
Oh,
the,
yeah, right. So again, the agreement says what it says. The construction hours are not binding. We're aware of that. This is another instance where our hands are a bit tied by the permit. If Energy is agreeing to try and use limited hours. If they don't, they're supposed to let us know. I think that right now the concern is mostly uncertainty. We don't know when construction is going to occur, how long it's going to be. Moving forward, there will be plenty of opportunities for vendors to come and brief the board on that. And we'll make sure people know. And if there are concerns, we'll raise them. We'll see if we can work something. I mean, maybe how long will construction be in a town like this, given we only talk about 8.4 megawatts.
It doesn't all occur all at once, right? So it would go and install piles and one.
then can you hand Kate sorry, Kate, just
Yeah.
the people at home, even though we can't hear them, they'll always be able to hear you.
Kate Millar and Energy. So the pile driving would occur in phases. So it would be at one field and then we would move to the next. So it doesn't take a year to install piles in one given field. It's a pretty quick event and we move on. The substation would probably take longer. That's National Grid scope of work and that's fairly involved, but a lot of that is electrical and not a very, noise producing event. So that clarifies, but once we have a construction plan, then it's absolutely right that we can put that together, bring that to the board, and make a plan.
Thank you, Kate.
Yeah. And anything else from the board? I mean, I guess one final thing, in terms of the 2% escalator we are not getting. I mean, yes, the town would prefer to have a higher escalation clause. But the towns look very carefully at this, and I think we understand that the $300,000 balloon payment is making up largely for the diminutive 1% escalation.
Thank you, Ben. Would any of the town board like to comment? Question generally?
I'll start off by saying that, we have been hard at work at this. And for quite a long time. We've listened to what our residents have said. And again, I appreciate the hard work of our attorneys on this, working on our behalf and for the residents' behalf. And good points were brought up tonight that I needed to hear. I will pass on to someone else.
Thank you.
I thank you, Amber, and thank you everyone for your comments and to our attorneys who have really been working with us and looking out for us. This has been a lot of work behind the scenes, a lot of hours. I'm sure any of our families can attest to that, and the people in this room. Is it perfect? No. Is it better than where it was? I would have to say yes. I would have to say yes, and you'll just have to trust us on that. Rush is a rural agricultural community. Many of us want to do whatever we can to help preserve that. We do have a local solar law that was worked on, the town passed it. The idea that we could be, overruled, I think is unconstitutional, and maybe somebody with deeper pockets than us will fight that on its merits and win. I'd like to see that just because. But I think we did a tremendous amount for everybody, at the same time. And, people who said we were anti-solar couldn't be spreading further untruths. I will just say that we are pro-solar. We are very aware of climate change. And for me personally, destroying prime agricultural land, you're taking away one thing for another thing. What's the net benefit? I don't know. I too personally have invested in solar panels at my home. So, you know, I really resent comments to say we're not pro-solar. But I think if you're concerned at all about climate change, you need to be looking at the bigger picture. You know, you can't get half the vegetables you used to be able to get from California because of climate change. Where are they going to grow those things? We have prime agricultural land here in Rush. I would like to do whatever we can to preserve that. We have a solar law that puts the town in a position to do their part. We have passed successfully other installations. We want to do what's right, but we have to look at the big picture. There's a lot of people impacted by this. I think we did a lot, and I thank also Invenergy for making concessions to help all of those people. We're talking hundreds of people who had directly impacted by a utility scale facility in the town of Rush. We could not but take this very seriously when you want to put a utility in the town in an agricultural community. And we did our best. I will only tell you that. But thank you, everybody, for working so hard to move this along.
Thank you, Gene. How about Dan?
Well, from the very beginning, I didn't think there was gonna be much chance of us actually stopping. Horseshoe Covenant becomes the governor, well, the state wants this to happen. But I think this agreement works best. It gives the town as much benefit as they possibly could get out of it. I think it's a good benefit, and I appreciate the work of Ben and the rest of the town board and working on this and getting it done. And Horseshoe is coming regardless, and it's coming, and at least we're getting some benefit from it.
Thank you. How about Dan Chase?
I will speak up. I was not texting in front of all of you. I know that's very rude, but I was texting Dan since we can't hear him. So I asked him if he had any comment. He said, I don't have a comment at this point. Dan, if you change your mind, you have my cell phone, so you can call us. So it's to you, Supervisor.
And I would say thank you. I don't think anybody knows any more than I do how much these people worked on this on behalf of the residents of Rush. And I'd like to echo Councilperson Morelli's comments about things that we've heard in the community, that we were anti-solar. We have never been anti-solar. I don't know of a board member who has been anti-solar. The whole issue has been where these facilities get placed. And that was 100% of the issue. And I don't hold Invenergy completely responsible for that, because the way was paved for them to do what they've done by the New York State government. And I couldn't help but resonate with Dan's comment. Horseshoe's going to come whether we like it or not. And it's going to be placed where the government allows it to be placed. We've, in this particular issue, lost our home rule authority. And I don't know if we'll ever get it back if they want to try some other tactics that would encroach upon the freedom of life that we live. So I want to make sure that David and Ben, I've been told by people that Ben is probably the best attorney we could have hired for this project. I was told years ago that David would be a great addition to this team. That's why he's sitting there. And that's why Ben's sitting there. And that's for the most part why all of us are sitting here. So thank you very much for your patience. Thank you very much for your support. And thank you very much.
And I'll just add one last thing. This isn't obviously a done deal. The town has a lot of work to still do depending on what is decided, oversight, things like that, from our archaeological monitor to the DPS monitors and all that. So we're not going to go away. We're going to be proactive as best we can for our residents that we represent. So would you like me to read a resolution?
How did you know that?
All right, let me put my glasses on.
You've been looking at my script, haven't you?
A resolution authorizing the execution of a host community benefit agreement and road use agreement with Horseshoe Solar Energy LLC. Whereas Horseshoe Solar LLC, the company, has received from the New York State Office of Renewable Energy Siting, ORAS, a siting permit to construct and operate a ground-mounted solar photovoltaic electric generating facility the company is developing on various parcels of land located in the town and in a neighboring town project. And whereas the town has commenced a legal proceeding challenging the issuance of the siting permit and seeking an order annulling the siting permit and remanding the matter to the siting board for a full adjudicatory hearing on the issue of whether local laws might be properly waived and whether the siting permit mitigates or avoids impacts on cultural and archaeological resources within the town, the appeal. And whereas the town and the company have been engaged in good faith negotiations to determine whether they may be able to resolve issues concerning the project and therefore discontinue the appeal. And whereas the town and the company have negotiated a proposed host community benefit agreement, the HCA, and a proposed road use agreement, RUA, which the town board believes will address and or mitigate as much as possible its concerns regarding the adverse impacts of the project on the town. And whereas the town board public hearing on July 19th, 2023 at 7 p.m. at the Rush Town Hall, and all interested persons were permitted to speak on whether the town should enter into the HCA and RUA. And whereas the town board believes that entering into the HCA and the RUA would be in the best interest of the town, taking into account all of the considerations and the benefits from the HCA and the RUA and weighing them against the cost and potential outcomes of further litigation. Now therefore be it resolved by the town board of the town of Rush that one, the town supervisor is hereby authorized to execute the proposed HCA subject to receipt of further positive assurances from the county, school district, and IDA concerning Invenergy's proposed pile agreement in a form to be approved by the town's attorney. Two, the town supervisor is hereby authorized to execute the proposed RUA, subject to receipt of further positive assurances from the county, school district, and IDA concerning Invenergy's proposed pilot agreement in a form to be approved by the town's attorney. Three, the town supervisor is hereby authorized to execute any other document which may be reasonably necessary in order to effectuate the HCA or RUA. Four, in consideration for the town's entering in the HCA and RUA, the town's attorney on the appeal, Benjamin E. Wisniewski, is authorized to dismiss and withdraw the appeal with prejudice as may be provided in the HCA. It then says, I, the undersigned town of Rush, I don't, that's the further part, right? Is there a second?
I'll second it.
Any further discussion?
Yeah.
Councilman Chase.
Oh. Thumbs up.
Councilwoman Corbin,
Aye.
Councilwoman Morelli,
Aye.
Councilman Oliver.
Aye.
Supervisor Cusie.
Aye. I hope that this does not stop any resident from communicating with this board. regarding this agreement that we've entered into tonight. I don't want to see that stop out of frustration or anger or any other reason. Because we will still continue to monitor the situation and make sure that what we do best represents the community. I know we've got, as Mrs. Glocker revealed tonight, another large project coming into this town, or at least being looked at to come into this town. And we just don't want to give up to frustration and anger, etc. So thank you very much for your patience. And thank you very much for your support. I appreciate it. Can we move on to old business? We've got
No.
one item of old business.
We do.
No, that we do not. That this is the updated agenda
Oh,
that was updated.
wow. When you send out 27 different copies,
That must have been a nightmare.
I have a lot of them.
That's funny.
So, no, it's not. Sometimes I wake up in a cold sweat. So having no further business to discuss, I declare this meeting adjourned. All in favor?
Aye.
Aye.
Thank you again.
We are still on YouTube, everyone, so we will, you're being recorded, so as soon as we I can't close out, only you can. Pam. There we go.